Barney, who's standing to my right.
Good morning.
Your Honor, the PCT, my client wishes to set this matter for a preliminary exam. And if
all discovery is complete.
Yes, Your Honor.
You were going to say something.
And if I'd like to, when appropriate, address the condition of the bond.
Right away, this hearing shifts from routine scheduling into the real battlefield, bond conditions. That matters because bond is not just about money or release. It controls contact, movement, restrictions, and sometimes the entire emotional center of a case. Here, the defense is signaling that they want Judge Simpson to reconsider whether Mary Barney can communicate with the alleged victim, who is also the father of her children and the child she is currently expecting. That is already complicated. A criminal no-contact order is being pulled directly into family life, pregnancy, parenting, and jail communication. And the tension is obvious. Is this about protecting a complaining witness, or is it creating a situation where a pregnant defendant has no way to discuss her children, health, or family needs? Viewers, where should the court draw that line when criminal protection orders collide with family reality?
People would have their witnesses available July 2nd.
We'll do our best.
Preliminary examination in person will be set July 2nd, 2024, 9 a.m. That is before Judge Washington. Yes, Esteban.
Your Honor, my client is serving currently a less than a year sentence from Judge Barr right now. And the complaining witness for the felony portion of this current case that she's hearing today, the complaining witness is the father of her 3 children, and she is currently pregnant and is due in October. I understand that I've substituted the bond no contact with Mr. Greenlee, who is the complaining witness on the felony. He is the father of the children and the child to be born in October. My client, and I believe Mr. Greenlee, is in agreement if the court would be willing to waive or to amend the bond condition to allow her to have contact with him, phone calls from the jail.
Your Honor, it has been communicated to our office that the woman would like contact. I am vehemently opposed to that in this case. This is a case where I do believe Ms. Barney's phone privileges have been revoked because she contacted the victim 74 times in violation of the no contact order through jail calls. So I don't think that any modification of bond conditions are appropriate in this case.
Your Honor, if I could address that. So if they're monitoring all her calls. So if there's an issue with her calls, then certainly they have things they can do. Otherwise, given the background of the family background, the fact that she's due in a few months, I'm not sure what they're expecting from that.
The defense is trying to frame the restriction as impractical. Their point is simple. If every jail call is monitored, then the system already has a safety net. If something inappropriate is said, prosecutors can hear it, document it, and respond. But the prosecutor's position is much heavier. 74 alleged contacts in violation of the no-contact order. That number is not a small slip. That is the kind of figure that changes the courtroom temperature instantly. The defense is talking about pregnancy, children, and family logistics, while the prosecution is talking about repeated violations. That is the contradiction Judge Simpson has to weigh. Compassion on one side, compliance on the other. And in court, sympathy only goes so far when the record suggests someone has already ignored an order dozens of times. This is where "we just need communication" starts sounding very different once the court hears 74 times.
Certainly,
how long is she in custody?
How long has she been in custody?
Well, no, I guess.
This is the full year on the child abuse case before Judge Barr.
So I think that was in April.
That's correct.
May 15th. So there is a pending motion up in front of Judge Barr to change that, given she was denied access to the mental health court. So that is being addressed with Judge Barr right now in a couple of weeks or next week. But having contact with there's no way for her to check on her children, There's no way for her to talk to about her health. There's all these issues going on that communication.
What are the prohibitions on the child abuse case? So, I mean, I know she's under sentence, but
She has been sentenced to jail. Judge Barr was considering modifying the jail sentence if she were to be accepted to mental health treatment court, from which she has been rejected.
There's to answer your question, it's not about contacting the children. I don't think there's a no contact with the children, because or him. There's not a no contact in any of the cases. So that's why we're wondering why she's being.
Is that correct?
I'm not certain. If you give me a moment, Your Honor, I can check in the notes.
While they're checking that, typically I would need to hear directly from the alleged victim in this case before I would change anything.
He's here, Your Honor, if you want to speak to him. My understanding of the no contact or that issue, Your Honor, was no non-consensual contact with Mr. Greenlee.
Now the defense narrows the argument. They are not asking for open-ended, unrestricted contact. They are pointing to the wording, no non-consensual contact. That distinction matters. If the alleged victim wants communication, then the defense is saying the order should not block consensual conversations about children, medical updates, and family responsibilities. But criminal courts do not always treat consent as the end of the issue, especially in domestic cases. Why? Because courts worry about pressure, manipulation, intimidation, or emotional dependency behind the scenes. So even if both people say they want contact, the judge may still look at the bigger pattern. And that is what makes this hearing interesting. The defense is arguing language. The prosecutor is arguing risk. Judge Simpson is sitting between technical wording and practical protection. This is not just can they talk, it is can the court trust the situation enough to allow it.
Your Honor, my understanding of the prohibitions in the child abuse case, according to our notes, is that Ms. Barney was allowed to have contact through CPS, which was to be facilitated by the victim in this felony case. With the no contact order in place in this felony case, any facilitation of visitation through CPS facilitated by the victim here is not occurring.
So before she went into custody, she got from the family court, she got an order for completely unsupervised visitation with all her children. That's a court order from the circuit court. And the issue is more of the contact with Mr. Greenlee and having contact with him so that she can find out how everybody's doing. Education, medical decisions. He wants to check in on her. He is present in the courtroom if the court would like to address with him. But this is, I'm at a loss to why these two can't talk to each other. Certainly the prosecutor has the right to look at all their phone calls and see if there's anything inappropriate said while the case is existing. But beyond that, I don't understand why they can't talk to each other.
I'll indicate no non-consensual contact. I don't know that necessarily addresses, and I'll let Judge Washington address whether or not her phone privileges at the jail will be reinstated. But I'll order no non-consensual contact.
Thank you.
Court does call the case. People versus Carrie Dillard.
Project on behalf of Mr. Dillard. Carrie, would you state your name for the record once you're at the podium?
The hearing now pivots into a second case, and the energy changes fast. We move from Mary Barney's bond contact issue into Carrie Dillard's bond reduction request. This is a classic courtroom turn. One case ends, another begins, but the stakes stay serious. Dillard's defense is going to push the family provider angle. 4 children, construction job, living with his mother, no contact with the victim. That is a very familiar bond argument. Let him out so he can work, support his kids, and follow restrictions. But the prosecutor is about to counter with the part that changes everything. domestic violence allegations, a child calling 911, and a firearm being involved. That is the pressure point. When children and weapons enter the bond conversation, judges often become much less flexible. Should financial hardship outweigh public safety concerns when the allegations include a weapon?
Carrie Dillard. Judge, I'm asking that I'm representing on both matters. We're asking that this be set for exam.
Discovery is complete on both matters.
I believe so.
Do people have their witnesses available on both cases July 2nd?
Judge, may I address bond briefly?
Okay.
Mr. Dillard is the sole provider he's got 4 kids, ages 2 to 13. He would like to get back to his job at construction. He could live with his mother in Belleville. He will have no contact with the victim, who is the mother of the 4 kids. That being said, Your Honor, we're asking that the court reduce the $25,000 bond, which I believe set in both cases substantially. We'd ask that PR bond released if need be.
Judge, these are cases that happen within a day from each other. On June 9th, which was the same victim, the 13-year-old child was present. She was the one that actually called 911 in this case. There are obviously serious allegations involving a weapon that he brandished during the DV situation. So I believe bond is reasonable. We had originally asked for a $100,000 bond each case. $25,000 bond was granted. So we have to keep the same.
Judge, just very briefly, it's almost the same incident, Your Honor. Again, I'm not minimizing 2 charges, but it just carried over to the next day. And I believe the weapon was licensed to the victim. All that being said, Judge, we're asking that he be able to support his kids.
Defendant's motion for bond reduction is denied. Bond will continue. Preliminary examination will be set July 2nd, 2024, 9 a.m. before Judge Washington.
This from the heart. Judge, I know you've made your decision, but my client is asking me to ask you again. He promises not to have any contact with the victim. Whatever you're going to say, what are you going to say?
This moment is tense because the defense is making one last emotional push after Judge Simpson has already denied the bond reduction. That is risky. Once a judge says the motion is denied, continuing to press can either humanize the defendant or irritate the court. Here, the defense tries to let Dillard speak directly, probably hoping a personal explanation will soften the ruling. But the problem is the judge has already stated the core issue. The allegations involve a domestic violence situation continuing into another day and involving a firearm. Even if the defense disputes how the firearm fits into the facts, bond hearings are not full trials. The judge is not deciding guilt, he is deciding risk. That means allegations can carry serious weight before anything is proven. This is one of the harsh realities of bond court. Your full defense may come later, but your freedom gets argued right now.
Judge, I know you all know me, and the situation at hand, I just want to go backwards. I made a lot of strides through here. Not be in this position. I worked real hard not to even be coming back to the situation. If you can just grant me house arrest, other something, I'll be in jail. It's like
Here's what I know, and you're right, I don't know you. Here's what I know. The allegations that have come before the court is that there is a domestic violence situation which precipitated itself or continued into another day and involved a firearm. That's what I know.
You're not it never involved. Judge, for what it's worth, a firearm was found. There was no evidence that a firearm was pointed at anybody. It's just that a firearm was found.
Which is it was brandished.
Oh, Judge, I don't believe that at all.
It was found.
It was simply found that the weapon was licensed to the victim.
My ruling stays.
I'm sorry?
My ruling stays.
Thanks, Judge.
Oh, you want me to change it?
Oh,
I will do more than that if you want me to.
Thank you, Judge. We appreciate it.
Yes, I'm serious. Dead serious. Are you serious? No, he's lucky I had water because that could have gotten bad. Thank you, Ann.
That final exchange tells you exactly how quickly a courtroom can go from legal argument to judicial warning. Judge Simpson had already denied the bond reduction, kept the bond in place, and set the preliminary examination for July 2nd, 2024, before Judge Washington. The defense tried to clarify the firearm issue, arguing it was found and licensed to the victim, while Judge Simpson still held firm. His ruling stayed. The key takeaway is simple. In both matters, the court focused heavily on risk, compliance, and protection. For Mary Barney, contact was adjusted to no non-consensual contact, while phone privileges were left for Judge Washington to address. For Carrie Dillard, the bond reduction was denied because the allegations involved domestic violence, a child witness, and a firearm. This case shows how bond hearings can turn on details that are not fully litigated yet, but still matter immediately. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.